Good morning, everyone. Welcome to our Fair Access to Water webinar, where we're going to be talking about access to water policies across Queensland and the Human Rights Act. I'd like to start by acknowledging the traditional owners of the land on which we are facilitating this webinar. I'm at West End in Brisbane, so it is the Turrbal and the Yagara peoples. I would like to pay my respects to our elders past and present, and I especially would like to welcome and pay respects to any First Nations people who are joining us on the line today. QCOSS thanks the First Nations people for the gift of the Uluru Statement from the Heart. We look forward to supporting work that leads to a successful referendum to enshrine a First Nations voice to Parliament in the Australian Constitution, followed by Makarrata and Treaty. And we welcome the invitation to walk with our First Nations people. If you'd like to take a moment using the chat function that's at the bottom of the screen to let us know on which of the traditional lands you're dialing in from. We've had registrations from all across Queensland. So it's great to acknowledge the breadth of the country and the connection to the land of our First Nations people. For those of you joining us today, my name is Meg Martin. I'm our Human Rights Lead here with QCOSS, and I'm going to be your facilitator today. I'll just go through a brief outline of what our session outline will be. So we're going to discuss the outcomes from our research into water hardship policies across Queensland, look at some gaps for end users, have a discussion around the Human Rights Act and access to water, also looking at the Anti-Discrimination Act and how this could potentially be used to support tenants' access to water, and then also looking forward to the upcoming changes to the Residential Tenancies and Rooming Act and any potential recommendations for law reform that may move forward. I'd just like to note that our webinar will be recorded, and we will provide a copy of this and the slides in our presentation in our post-event email today, which we'll send out to everyone who registered. We have two speakers today as well. We have Dr. Gayatri Ramnath here with us, as well as Mary Flowers from Tenants Queensland. Dr. Ramnath works with QCOSS, and she has undertaken a review of the water hardship provisions and conducted a comparative analysis across states. In Queensland, water legislation, there is disparity across what is provided within Southeast Queensland as opposed to regional, remote and rural water supply across Southeast Queensland. So I'll give you a bit of background on our speakers today as well. Dr. Gayatri Ramnath is a Principal Advisor for Policy and Research at QCOSS. She has more than 15 years of diverse experience in policy and has held advisory roles, including government, academia, think tanks and not-for-profit sector. She's worked in international development as a program evaluator for a number of years before working on domestic policy issues in Australia. And she is passionate about issues related to gender, inclusion and equality, and leads QCOSS work on living affordability and gender equality. She also holds a Master's in Economics and a PhD in Public Policy. Mary Flowers is our second speaker today as well, and Mary has worked with tenants for 15 years. She, having worked at community legal centres in regional New South Wales for most of that time. Mary's worked in policy and law reform as well with Tenants Union of New South Wales, and she has received the prestigious Dead Rabbit Award. Mary has worked extensively with First Nations tenants, advocating with housing providers and representing them in the New South Wales Civil and Administrative Tribunal. And Mary has been a long-term tenant, and she's also experienced short periods of homelessness herself after the floods in 2017. So she speaks from personal lived experience too. Mary was appointed a legal officer with Tenants Queensland in 2021, and she works with clients who are currently incarcerated in prison in Queensland. She advocates with housing providers and also represents clients with matters before QCAT, the Queensland Civil and Administrative Tribunal. Mary also provides tenancy advice to staff delivering the QSTARS program, which Mary will talk a little bit about, and other organisations who are supporting tenants in their role. So just a small bit of housekeeping before I pass over to Gayatri. We are broadcasting a Zoom, as I'm sure you're all aware. For those of you who may still be a bit unfamiliar with Zoom, if you hover over the bottom of your screen, you'll see chat functions that can pop up. If you have any questions, if we could save those to the end for our speakers, that would be great. As I said, the session is being recorded, so we will provide a copy of that at the end. But if you are not so keen on being recorded, this may be a time for you to want to opt out of the session. So I am now going to hand over to Gayatri to discuss the findings from the Fair Access to Water report.
Thanks so much, Meg, and thanks for that great introduction. I would also like to start by acknowledging the traditional custodians on the lands on which we meet. And I'm in the Turrbal Niagara people's land here in Brisbane. And I'd like to pay my respects to elders past, present, and emerging. So with the water hardship in Queensland, so I will provide a bit of context for today's discussion. So as Meg mentioned earlier, we reviewed legislation into hardship provisions into regional Queensland and compared these with Southeast Queensland. We also reviewed a sample of water provider websites to identify how water hardship provisions look like in practice. And the final bit is we compared water hardship provisions across jurisdictions in Australia. So I'll just quickly provide an overview of the kinds of disparities that we found for water consumers across our state. Next slide, Meg. So there is water disparity in terms of hardship provisions between Southeast Queensland consumers and regional Queensland consumers. So in Southeast Queensland, under the Southeast Queensland Water and Wastewater Consumer Code, providers must have a hardship policy in place to support customers experiencing financial difficulty. In Southeast Queensland, water providers must also allow consumers experiencing payment difficulties to pay and account by installments under a payment plan. Water providers and SEQ cannot charge interest on debt consumers are paying off under a payment plan. Providers cannot disconnect customers from water for non-payment, but they can restrict flow if they've not paid their bill, excluding people who are in hardship cases. Southeast Queensland water providers must issue a reminder notice that includes advice about what help is being available if they're experiencing financial difficulties. And customers in Southeast Queensland also have access to specialist water dispute services provided by the Energy and Water Ombudsman Queensland for complaints and disputes. So how this compares to regional Queensland is the code, the water and the wastewater customer code does not apply to customers outside of the Southeast Queensland region. And how this impacts consumers in regional Queensland is that under the Local Government Regulation Act, water is typically billed as part of the rates notice. So under the local government regulation, councils may offer a concession for water charges in case of hardship, but they're not actually required to do so. Councils can apply interest rate. They may recover overdue water charges by bringing court proceedings against the liable person. If water charges remain unpaid for 3 years, council can sell land to recover the cost. Further, under the Water Supply Act and other legislation, councils must set their own customer service standards, and performance against these standards are not actively monitored, or data is not easily accessible. The guidelines state that councils should include information about hardship policy on their water bills, but this is not a requirement. Regional water consumers don't have access to the Energy and Water Ombudsman Queensland. They have access to the Queensland Ombudsman for any disputes and conflicts. Complaints are handled by the Queensland Ombudsman in regional Queensland. Regional councils do not have the authority to disconnect or restrict flow for non-payment of water bills. And when we searched the websites of the nine councils for hardship plans, it was a bit hard to access hardship plans on their websites, though many of them have this in their consumer charter. But this is not really easily accessible for people who are looking for this kind of support. So when you look at tenants, because tenants are not, they don't have a direct relationship with a water provider, both in Southeast Queensland and in regional Queensland. The hardship provisions do not really cover tenants, and Mary will speak about this a bit more, and so will Meg. And lastly, when we did a comparison of other states, we found that Queensland and New South Wales were two states that have significant disparities in water rights between its residents. So in both these states, regional residents may be getting varying levels of assistance because water hardship provisions are not a requirement under legislation. Tenants are not covered, and so that is a significant gap in terms of who, which end user and which customer gets hardship provisions in our state. So with that quick overview, I will pass on back to Meg.
Thanks so much, Gayatri, for summarising the findings from that water report that we undertook. I'm now going to pass over to Mary Flowers from Tenants Queensland to discuss both some of the work Tenants Queensland do, but also looking at some of those disparity issues or the gaps for those end users of water, which are often tenants within Queensland.
Thanks, Meg. I'd like also to acknowledge the traditional owners of the lands we meet on today. Aboriginal and Torres Strait Islander peoples have and continue to suffer from the laws and policies imposed on them by decision makers in this country on land which belongs to them and was taken from them. As a result, First Nations people continue to be overrepresented in many areas of the legal system. I acknowledge elders who are no longer here and Aboriginal and Torres Strait Islander people who are here today. I further acknowledge emerging First Nations leaders who are using their voices to teach us about the importance of Aboriginal culture for all Australians. So moving on from Gayatri's research, the end users are often tenants in properties where water issues arise. And just before I go into that, just a little bit about Tenants Queensland. It's a community legal centre specialising in tenancy law, and that's very expansive. What is tenancy law also includes rooming accommodation, movable dwellings, so people living in caravan parks, and other types of accommodation like what is reasonably common these days, living in motels and hotels, sometimes Airbnbs. So basically, for anyone who's living somewhere and paying money to do so, it generally falls under the work we do. And so we and the main focus of our work is working with vulnerable people facing disadvantage with the workers that we do. So we've got advice and case workers who work across the state. We also have some specific workers in the domestic and family violence space, and particularly working with other service providers in educating them about tenancy rights for victims and survivors of domestic and family violence. We have a new financial counsellor on board who's available to assist tenants who are facing, often if they're facing problems in their tenancy paying the rent, they're also facing problems in other areas of their life with other debts. We've got community education workers across the state going out to provide assistance and education to other organisations. And we've got a lot of resources, and they are on our website, on the Tenants Queensland and the QCOSS website. And we're constantly developing those, and certainly in response to the new legislation, we've got more resources coming. So just to show you where we are located. So Tenants Queensland operates the QCOSS program, which is probably what most people are familiar with. This is the advice and casework that we offer. So we've got offices, you can see there, Southern Queensland, Brisbane, North, Rockhampton, Townsville and Cairns. And then we work with a number of partners to deliver the QCOSS program in other areas. We've got at the bottom of that list 3 community legal centres. Sorry, there's 4 community legal centres. Task at Toowoomba is also one, and 3 different other organisations who work in their own capacity within their organisation to develop that program. All right, so these are some of the issues that tenants will contact us for assistance with. And the first one, liability for water. It's a question that is often asked, you know, is the tenant or the person calling us responsible for paying for water if that demand is made of them? And in subsequent slides, I'll show you the 18A tenancy agreement to just go into that in a little more detail. So water meters and sub-meters, sometimes it's not clear where those meters are they on the tenant's property? Do they relate to more than one dwelling? Is a sub-meter inside a property, has it been installed by somebody competent? What is it measuring? So all of these questions come up. And then water bills, and that's a big one. So looking at how often they come out, whether they're passed on to the tenant in a timely manner after they've been issued, whether there's a significant cost difference between one billing period to the next. Those are some of the questions there. Water leaks also comes up. So if you've got a tenant that has a significant increase in their water bill from one billing period to the next, perhaps that may be a water leak, and that could be a concealed leak. And it's often difficult to get a lessor or a real estate agent to investigate because sometimes they think the tenant's making up stories. They just assume that the tenant is using more water. Water-related repairs. So you've got, you know, something as simple as a leaking tap to something more significant related to water. And then water efficiency. So that comes up too. So all properties have to be water efficient before charges are passed on to the tenant. And there's often questions about that because tenants have to, unless they are provided with evidence of a water efficiency certification, they take the real estate agent or the lessor's word on that. Okay, next slide. All right, so this is the 18A General Tenancy Agreement. And at the moment, it's quite small. Okay, thank you, Meg. And so if you go down to, these are all of the fields that need to be filled out on page 1 of this agreement. And if we go on to the next slide, which is page 2, and when we're talking about water, we're looking at item 12 on the 18A, and particularly 12.2 is the tenant to pay for water supply to the premises. So that's the first place we look. And when we talked earlier on the previous slide about is the tenant liable for water, this is the first place we look. And then we look, sometimes that is blank on an 18A. So we have to go elsewhere to see if we've got any other clues as to whether the tenant is liable for water. So if we go to the next slide. All right, so this is these are the clauses within the 18A, particularly 17. on, and that refers to sections 164 and 166 of the Residential Tenancies and Rooming Accommodation Act. And it specifies there about how water can be charged. I'm not going to read it all now. If we move on to the next slide, here's another clue. So I said that maybe on page 2, 12.2 might be blank, or sometimes it's ticked yes and no. And so you might look here to the special terms. And this is a really good clue anytime you're looking at an 18A tenancy agreement to see what the special terms say. Sometimes there's quite a few surprises I find in there when I look at them. And that might give us a clue about water. Okay, next slide. So just a couple of decisions there. But the 3 cases that are here are all hyperlinked. And so you're able, when you get a copy of these slides, you'll be able to click on them and go straight to them. But if you're not so inclined to read cases, I'll just give you a little bit of a summary of those. So the first one, McGrath Property Management, Blimber and Christo and Vanderwood. So this was a matter where there was a compensation claim made by the real estate agent at the end of the tenancy for damage to floors, for a new garage remote, paint work, removal of a tap and water. And this was an appeal matter. The real estate agent appealed the decision. And this was because the tribunal, the original tribunal, didn't find in their favour. So the appeal tribunal found that the property was water efficient and there was a special condition. So in the previous slide, I said that special condition can have a lot of surprises in it. In this particular case, the special condition stated that the real estate agent would forward water invoices every quarter, requiring payment by the tenant within 1 month. So what actually happened was the real estate agent breached the agreement by not providing those invoices in a timely way. The tribunal stated a tenant is entitled to be made aware of the cost of water consumption as and when the invoices fall due. The failure to pass the costs on is a breach of the lessor's duty to take all reasonable steps to mitigate its loss. So we like this case. It's something that we refer to and give this to tenants to support them if they find themselves being lumped with, say, 2 years of water bills in one hit. The next case, North Sea Real Estate and others, and Cavardis. This is a 2017 matter. This was interesting. This was a high-end property in Brisbane where the rent was $8,255 a month. The tenants paid a $10,000 bond, not your average tenant. So the tenant stopped paying rent due to the failure of the lessor in maintaining the property. The lessor took the tenant to QCAT and QCAT terminated the tenancy. After the tenancy ended, there was a compensation claim made by both parties on each other. The lessor claimed in excess of $50,000 from the tenant, including an amount for unpaid water. The tenant sought a rent decrease for the loss of the use of the air conditioner and the pool, which when you pay that much rent, you would be wanting those to work. There is a jurisdictional limit at QCAT of $25,000. So in the meantime, the lessor had made an insurance claim for the unpaid rent and got a payout there. So they ended up reducing their claim to the jurisdictional limit, which was $25,000. So what did QCAT find? So they found the property was not water efficient and it was likely there was a concealed water leak leading to high water bills. And they found that the tenant was not responsible for paying for the water accounts. They still had to pay $15,000 to the lessor for the other issues. So if you're so inclined, when you've got plenty of time on your hands, that is an interesting case to read. All right, the final case there, Copying and Property, Central Australia. This is another appeal matter. So the tenants sought a refund of water charges paid because the property was not water efficient and the original bills were not provided to the tenant before the demand for payment was made. QCAT declined to make this order, and then the tenants appealed the decision. So the appeal tribunal found the property was not water efficient and therefore only a reasonable water charge applied. They found that the method of charging water changed from one fixed term to the next. So in this tenancy, the tenant had been there for 2 different fixed terms and the water charging method changed in the second fixed term. So the appeal tribunal ordered that the real estate agent provided to the tribunal all original invoices, and otherwise they were to refund the tenants $3,000 for the water charges that they paid. And that matter was remitted back to the tribunal, so not the appeal tribunal, for a determination. So we don't know how that went, but the principle is there at the appeal, from the appeal tribunal. All right. So what we're seeing more and more across all of the work we do, not just in Tenants Queensland, but in the community space, is climate change and natural disasters. So we've seen the devastation of floods this year, and what I didn't say earlier was that Tenants Queensland has some specific workers looking at flood. So we are very busy in this space. So while the waters have gone down, the mould has started, and the mould has taken over many properties, and tenants are either looking to end the tenancy or to continue to live there because there are no other properties, and deal with the mould and seek compensation. So this is becoming more and more of an issue. If you can remember, we have had droughts before the floods where we had water restrictions, and the way that plays out for tenants, often in different ways, like perhaps the lawn died, perhaps the gardens died, and you've got a lessor who might be seeking compensation from a tenant because they didn't water the trees and the gardens. We've got storm and rain events which are ongoing, particularly more so sometimes of the year. And what happens is that before things are rectified from those events, we have another one. And so we just have this, one event after the other, and the property doesn't recover, and the issues just keep compounding, and the insurance costs for the lessor keep going up. And sometimes, some lessors might decide to not insure or underinsure, and then that leads to a whole lot of issues around rectification of the property. We're seeing increased temperatures, and that creates issues for tenants within properties. And this new emerging thing about whether housing is a right or a privilege. Now, we here would say it's a right. However, we're hearing, more from different sectors that it's more like a privilege to have a house to live in. Just a couple of case studies that we've seen at Tenants Queensland. So the first one there is a very recent one where this was a matter related to the flood and mould. So there was an agreement. So one of the ways a tenancy can end, apart from a tenant or a lessor giving a notice to leave or a notice of intention to leave, is by mutual agreement. And so this was a tenancy that ended by mutual agreement. So the terms and conditions of how the tenancy ended were set out in this agreement. And the tenant had suffered by significant mould in the property. So one of the conditions in that mutual agreement was that the tenant return the property in a clean condition. And that happened. However, it didn't meet the standard of the real estate agent. They wanted it cleaner than the tenant returned it. So they took the tenant to the tribunal, and the tribunal didn't agree with the real estate agent and dismissed the claim. So it was a significant claim so, you know, on one hand, they let them out of the tenancy because of the mould throughout the property. On the other hand, they want to punish them by taking their bond from them and charging more than the bond for some other standard of cleaning that's required outside what was set out in the mutual termination agreement and in the Act. So that's that one, and we're probably going to be seeing more and more of those type of matters come before us. So the next one, this is one that comes up reasonably regularly because you know, ventilation hasn't been part of you know, the requirements of a lessor to consider in a rental property. And Meg's going to talk a bit more about this, but in this particular matter, you've got a tenant, a mother with young children, confined to a small area of the home in the heat of summer because the oppressiveness of the heat meant they couldn't use the property. And so, you know, what we see, what we're saying is, you know, these shoddy conditions that tenants are living in are just replicated over and over. Tenants can't do anything about it. In this case, there was nothing the tenant could do about it. There were no properties to rent. Anything else was considerably more than what they could afford. And in any case, you know, even if that wasn't the case, you know, bringing an action against a real estate agent or a lessor is often beyond a lot of people. So they endure these conditions. And as I said before about the new norms, the right and privilege, we know that TICA, who operates one tenancy database in Australia, talks about renting as a privilege. We don't agree. Thanks, Meg.
Thanks so much, Mary, for your insight into what's happening for tenants out there, particularly around these emerging areas around water, such as mould and even the ventilation issues that are not ones you think about as being primary concerns, but are becoming more and more prevalent. I'm going to move on to human rights and water. And I was going to start big, of course, and filter on down by first identifying some of the international treaties and conventions that Australia is a part of. So there's quite a number that Australia is a part of. There are 5 in particular that I've listed there, and I've hyperlinked, so when the slides come around, you'll be able to click on them, that talk to particular rights or standards of living around water in particular. So the International Covenant on Economic, Social and Cultural Rights at Article 11 talks about there being an adequate standard of living, that everyone has a right to an adequate standard of living, including adequate food, clothing and housing. The CERD, the Convention of Elimination of All Forms of Racial Discrimination, Article 5, E, 3 and 7, talks about the requirement that countries guarantee the right to everyone to housing without distinction of race, colour, national origin in compliance with fundamental obligations. and also talks about those economic and social and cultural rights as a right to housing. The Convention on the Elimination of All Forms of Discrimination Against Women, Article 14, has the required measurement to be taken to ensure women in rural areas enjoy adequate living conditions, particularly in relation to housing, sanitation, electricity and water supply. The Convention of the Rights of the Child, Article 24 and 27, states that to combat disease and malnutrition, children should have access to appropriate healthcare, including nutritious foods and clean drinking water. The CRPD, the Convention of the Rights of People with Disabilities or Persons with Disabilities, Article 28 recognises the rights of persons with disabilities to adequate standards of living, including adequate food, clothing, housing. So there are a number of conventions and treaties that we're a part of that talk to this adequate standard of living, which includes access to water. The UN Committee itself has stated that the human right to water entitles everyone, and I struggle to remember this in its entirety, to sufficient, safe, acceptable, physically accessible and affordable drinking water for personal and domestic use. So this includes consumption, cooking, and domestic hygiene, so sanitation as well. So it's quite a number of categories there, but going big and then coming down. As you may be aware, Queensland has a Human Rights Act. We're one of 3 states and or territories within Australia to have human rights legislation. The Human Rights Act within Queensland does not have a right to water. So there is not a section within our Human Rights Act or within the Victorian Act or the ACT Act that states all people have a right to water. What the HRA, the Human Rights Act, does require is that public entities, which includes functional entities, have to make decisions that are compatible with human rights. So this includes water providers. Water providers would be included as functional entities. A functional entity is an organisation that provides services similar to what a government would provide if the government was providing those services. So a corporation that privately runs a correctional facility would be considered a functional entity. Services that provide the water facilities as well would be considered functional entities. We have 23 rights within the Human Rights Act, so there is an expansive list of rights, but as I said, not one that entitles or specifies or spells out a right within our own Queensland legislation of a right to access to clean, accessible, affordable drinking water. This does not mean, though, that the Human Rights Act doesn't apply in decision making. So all functional entities must make decisions compatible with human rights. Human rights can be limited in decision making, but there's a 3-step process to apply here when we look at that. And that is looking at step 1, what is the relevant right? Step 2, what is the impact to that right? And then step 3, if that right is limited, is it lawful? Is there a purpose to the limitation? Is it rational? Is it necessary? Is it fair and balanced? So is it reasonable, justified and proportionate? That's really what you're looking at there in that 3rd limb of the test. So when we look at human rights and access to water, there may be human rights that apply that aren't specific, your right to water. These could include, and this isn't a fulsome whole list, it's always going to be dependent on the person and their situation at that point in time. So it could include recognition and equality before the law. Every person has the right to recognition before the law and is entitled to equal protection from the law. It could include a right to life, particularly if you need water because of particular disabilities or access to medical equipment as well, specific to your needs. Property rights may also be affected here. Privacy and reputation may be affected, and cultural rights, particularly for Aboriginal people and Torres Strait Islander peoples. There may be particular cultural heritage or traditional rights or passages that need to occur as well. The Anti-Discrimination Act and water, and I just wanted to touch on this as well, may also have some impact here. So the ADA, the Anti-Discrimination Act, applies to anyone providing a good or service. This can include the provision of water. So the discrimination must relate to at least one of the attributes within Section 7 of the Anti-Discrimination Act. I'm sure we're all fairly familiar with people being multifaceted. None of us are ever just one side of one coin. We tend to have multiple attributes that may come into account, but the attributes that Section 7 lists is quite an expansive list. So it includes you cannot discriminate on a person based on their sex, their relationship status, their pregnancy, their parental status, breastfeeding, age, race, impairment, religious belief or religious activity, political belief or political activity, trade union activity, lawful sexual activity, gender identity, sexuality, family responsibilities, and also any association with or relation to a person identified on the basis of any of those attributes. So discrimination doesn't have to be direct, it can be indirect as well. And it can extend to discrimination in accommodation. The Queensland Human Rights Commission has prepared a number of fact sheets around what this discrimination has looked like in matters they've seen. So I've hyperlinked that and I'll send that out to you as well. So if you are so inclined, you can read more on that, because the Human Rights Commission have put a lot of work and information into identifying what some of these discrimination areas look like. So it is looking at that water suppliers and landlords, potentially real estate agents, must not discriminate on a person by failing to provide a service, the terms of which the goods or service are supplied, the ways in which the goods or service are supplied, or by treating the other person unfavourably in any way or in connection with the supply of goods or services. Now, looking forward, you may not be aware, but there are changes currently happening and will continue to happen to the Residential Tenancy and Rooming Accommodation Act, leading up until September 2024. So what has already changed within the legislation has included strengthening protections for renters who are experiencing domestic and family violence. What is going to continue to change in the future, and I've listed quite a number of those changes there, but particularly around water and for today's topic, the two biggest changes are around new tenancy arrangements, and for all tenancy arrangements, the definition of what is a minimum housing standard. So these are coming into effect in 1st of September 2023 for new tenancy arrangements. So that's those tenancy arrangements going forward. But from the 1st of September 2024, all tenancy arrangements will have this definition of what is a minimum housing standard. The Act allows for a prescribed minimum housing standard to be by regulation. So this can include setting minimum standards around sanitation, around drainage, around cleanliness, repairs, ventilation as well, and also protections from damp and its effects, so the ever-present issue of mould at this point in time, as well as the provision of water supplies, storage and sanitation facilities. Currently, as the regulations sit, the limitations around water, as Mary identified, is that Section 22 that looks at what some of those water efficiencies are. So there is the potential that this is going to look at ensuring there are amendments for renters and looking at what is safe, secure and functional in these rental agreements around what is that minimum standard for rental agreements. And that applies to both private landlords as well as anything under the RTA effectively, any rental agreement in place. The amendments will also allow for tenants to apply to QCAT for enforceable repair orders. So QCAT can review rent increases and reduce rent for the purposes of recovering costs or complying with those minimum housing standards as well, if the property doesn't comply with those minimum housing standards. And Mary identified some of those cases that are already occurring as well, around where there are those rental changes. And looking forward, what's the next step? I always like to look at, we're here now, but where can we go in the future with this as well? So the changes to the Residential Tenancy and Rooming Accommodation Act, I think, is a positive step forward in setting what those minimum standards are. But legislation, of course, can only take us so far. This will also be dependent on case law that is created around the interpretation of this legislation too. There is an inherent power imbalance for tenants in this space, particularly those who are concerned that seeking to uphold their rights by pursuing an action through QCAT could result in a termination of their tenancy. We fully acknowledge that, and that's a difficult expectation to place on tenants, to create the case law around issues that directly affect them when there is that power imbalance. There's also a need, looking at the work Gayatri has undertaken, of functional entities appropriately considering the Human Rights Act in decision-making around water and utilising it in everyday practice as well in their policies and procedures and decision-making, to make sure we are considering the individual rights of people involved in these decisions as well. I'm just going to stop sharing, but I was going to open it up if anyone had any questions. I can see Mary's already put in there a recent example of discrimination in housing. But if there are any questions from the group, if there's any points of reference people would like to put out, please raise your hand, jump on the chat. If you'd like to type it out there on chat or speak, we are open to hearing from you. And Mary, if there was anything that I'd missed that you wanted to add as well, I am always welcome to hearing from you a bit more.
I think you're right. We just need to watch this space with regard to the new legislation around minimum standards. Just a reminder that they don't come in till 2023 and 2024. So still a way off, but we can be looking forward to that.
I know 2023 seems quite some time away, but we are already in August. I don't know when that happened in 2022, but we are in August already. So it's not that far away. It's just over a year nearly for those changes to come into effect. Well, I can't see any questions, but as always, if anyone has any questions that they'd like that pop up after the webinar, you're more than happy to email them through to myself or to QCOSS here, and we're more than happy to address those and take them on notice. I am happy to wrap up our session there, because I know that was quite a bit of information, and I'd like to thank our speakers, Dr. Gayatri Ramnath and Mary Flowers today, for taking the time to share their knowledge and insight with us. Don't forget, you can like and follow us on our socials. It includes Twitter, Facebook, Instagram as well. We'll send out our end of event email as well that will have the slides. And so thank you so much everyone for your participation today.